Today we are talking about the potential protections available to small businesses under the Wisconsin Fair Dealership Law, also known as the WFDL. The WFDL protects certain types of businesses doing business in Wisconsin that are considered dealers of another company's products or services from certain unfair treatment, including terminating or not renewing the dealer's contractual rights to sell the grantor's products or services and substantial changes in competitive circumstances of the dealership without good cause. The rights provided by the WFDL are in addition to rights under traditional contract and common law and are important rights for covered dealers to consider in protecting their businesses from prohibited unfair treatment. It is also important for manufacturers and other franchisors and licensors to consider the potential application of the WFDL to their distributor relationships. Take a look at our separate discussion on WFDL grantor considerations for more information. The WFDL entitles a dealer to recover its attorney's fees and expenses if the dealer can show that the grantor or the dealership violated the WFDL. The WFDL also allows the dealer, if successful, to get injunctive relief to stop a prohibited termination or other act in violation of the WFDL. The first step in determining if your business may have rights under the WFDL is to consider whether your business is a dealer situated in Wisconsin. A dealership is an agreement, either expressed or implied, oral or written, by which a business, defined as a dealer, is granted the right to sell or distribute goods or services or use a trade name, trademark, service mark, logo type, advertising, or other commercial symbol in which there is a community of interest in the business of offering, selling, or distributing goods or services. The courts have identified a number of criteria for determining whether there is a sufficient community of interest that a dealership exists under the WFDL. And over the years, a variety of businesses have been found to be dealerships protected by the WFDL, including fast food restaurants, equipment dealers, grocery retailers, service providers, and even Girl Scout troop councils. There are few, if any, clear-cut situations that determine that your business is or is not a dealership, so you should consult an attorney knowledgeable about the WFDL to assist you in determining if your business might qualify as a dealership protected by the provisions of the WFDL. If your business is found to be a dealer under the WFDL, in addition to protecting your business from certain actions without good cause, the WFDL also requires, except in certain circumstances, that dealers under the Act be given at least 90 days written notice of a termination, cancellation, non-renewal, or substantial change in competitive circumstances, including all of the reasons for the termination or other action. The WFDL also requires that the dealer be given at least 60 days in which to rectify any claimed deficiencies. Good cause under the WFDL includes failure by the dealer to comply with essential and reasonable requirements imposed by the grantor that are not discriminatory as compared to requirements imposed on similarly situated dealers, or bad faith by the dealer relating to the dealership. It is important to note that the statute of limitations applicable to the WFDL is very short, and the time period to file a lawsuit may trigger when the grantor, a product manufacturer or service provider, communicates to you that it is taking an action that may be prohibited by the WFDL. If you are experiencing unfair treatment from a franchisor or other business that provides your business products to resell or distribute, or grants you the right to sell products or services using its trademarks or other commercial name or symbol, and especially if your business is threatened with termination by an important product vendor or trademark licensor, you should promptly seek legal counsel from an attorney experienced with the WFDL to determine if action under the WFDL or other applicable Wisconsin law may be appropriate to protect your business. If you'd like to learn more, please feel free to contact us anytime. The information available in this video is for information purposes only and not for the purpose of providing legal advice. In the event you are in need of legal advice, you should contact your attorney with respect to your particular issues or problem. Transmission or receipt of information on this video does not create an attorney-client relationship, and it is not intended to be advertising. Wisconsin dealer law does not desire to represent anyone viewing this video who is in a state where this video fails to comply with all laws and ethical rules of that state. None of the information or advice contained in this video is intended or written to be used relating to any federal tax issue and cannot be used by any person for the purpose of avoiding any federal tax penalties.